We are gonna.
Okay, it's letting me record. Okay.
To do.
You ordered some too. Dang.
All right. Wonderful, wonderful. Well, good morning, everybody, and welcome to Ask the Experts Real Estate Insight Series. We have a wonderful treat for you all today with the fabulous Shema Freeman. We're going to be talking about probate and estate planning and how it pertains to real estate. But to get started, Vanda, go ahead and introduce yourself.
Hi, I'm Vanda Crossley. I am a licensed realtor in the state of Texas, and I'm also a licensed loan originator in the state of Texas. So I've been doing loans for 2 years now, and I've been a realtor for 8 years. And I'm also a mentor with eXp Realty, and I'm holding my license with Loan Factory. So if you have any questions about the loan process, I'd be happy to help you. And welcome.
Yes, yes. And I am Janila.Brown, real estate entrepreneur. I have served the community for since 2018, and I am working with buyers, sellers, and investors to make their real estate goals come true. I am the counseling realtor and happy to serve you. I love Jesus, good food, and just believe in serving people well. Education is my primary focus, educating and empowering you to realize your real estate goals. So, welcome to Ask the Experts. We are so happy that you joined us. If you have any questions, please put them in the chat and we will get to them as soon as possible. If you are listening to a recording, you can comment any questions that you have and we will follow up with you. All right. So we're going to go ahead and get started. And basically, today we are going to start with our market update. So, Vanda, as she stated, she is with the Loan Factory. So, she's going to provide us with our market update.
So as we know, the market is a little volatile right now. We have the government who's on strike, so the FHA and the VA loans are all being delayed. The interest rates are hovering around 6.4%. But one of the new things that's coming about in the loan industry is the FICO scores are now going to start being used instead of them using the tri-merge accounts where you have Experian and those other ones. And it costs about $85 per person to get that run. So now they're going to start using a FICO score. And with that FICO, they're going to be able to count your utilities in there, your cell phone payments, things like that, that hadn't been counted with Experian and those people. So that's changing a little bit. So people might be able to get qualified now a lot sooner. So it's changing a little bit. But as a mortgage loan originator, I see this as a win, and I think this is good because a lot of people do have those types of bills that's not reported to the credit bureau, and it may be stopping them from being qualified to purchase a home. So, if you have any questions about that, I'll be sure to do some more deep dives in that. And as it comes about, I'll share that information. And then the next time we'll be able to talk about how you can increase your credit score and so that your FICO and your bureau scores can increase. So that's good news for the industry.
That's fantastic news because that's definitely been a huge thing with people being able to qualify because they've been paying rent payments, they've been paying their bills on time, and they may have had trouble along the way. But to get credit for that,
Yeah.
that's awesome. That's really great. So wonderful to hear. Thank you so much, Vanda, for that market update. And now we are going to get into our hot topics. So, one of the hot topics, Vanda, you had brought to our group was pertaining to realtors specifically and our signage for open houses. Can you talk to us a little bit about that?
Yes, because of the bill that passed on September 1st. Oh, don't quote me on the number now. You caught me off guard. SB 311 or something like that. It's illegal unless you have written permission from the homeowners association or the property owners where you place these directional signs, they can fine you up to $5,000 per sign after your third offense. So, of course, you'll get a warning first. They'll probably take your sign, send you a letter, warn you about it. And then the next time they'll fine you $2,000. And then the third time, each sign can be up to $5,000. So that's a lot of money to be putting your directional signs up. But of course, you can put it in front of the house where you're hosting the open house because you will have written permission from them in your listing agreement to advertise that. But if you put it at the neighbor's house at the corner trying to get people, then you just got to get written permission from that neighbor, which could be good because now you're knocking on the door, you're introducing yourself, and you're saying, "Hey, I'm having an open house here tomorrow." I said, "Okay, if I put my sign here, could you sign this and give me permission in case somebody, there's a Karen in the neighborhood who will report you because she's not getting any business and you're in her neighborhood doing this open house. She'll take a picture of it and send it in and. So just eliminate that and just come up with a little, one-liner. I give permission. And then when they have it, bam, here you go. I got permission. I'm good to go. So that's my advice on that.
Yes, yes, very good advice. Very good advice for sure. Because that I definitely can see that being an issue. And keep in mind also if you're hosting for someone else's listing, make sure that you get that confirmation and send that over to the listing agent as well. Because they're the one listing the home, so they're the one that may be responsible um in that instance. So just make sure that you're still collaborating with everybody in the industry to keep ourselves safe and protect your pockets. Because that's, yeah. Bandit signs have always been a thing, a nuisance, but at the end of the day, giving good instructions in the MLS, making sure that you're clearly communicating in the invitations, where the house is. And we now have GPS, so people can most often, they're going to Google it anyways and put it in the GPS. But it's still helpful because you get plenty of walk-ins that just saw the signs and were led to the home. So interesting to see how this continues to unfold. But to the realtors listening and tuning in, just stay compliant. Just stay compliant and save your money. Okay. Some other hot topics. So another hot topic was the um, DR Horton and making sure that property taxes, whenever you are working with a lender or new construction, this is mainly pertaining to new construction as the home buyers are suing DR Horton. But this can happen with any lender in the disclosure piece of making sure that you are asking whether that payment, your initial monthly payment, for your mortgage is going to be based on the land's property taxes that the builder's currently paying or that currently being paid, or is it going to be based off of the land plus improvements? So make sure that you're asking that so that you're aware, so that you can get a correct estimate, including in a proper escrow analysis up front, right? They estimate taxes anyways, right? So it may be a little off, but certainly not as jarring and as $1,000 or $2,000. You can go ahead and start making those payments up front in addition to in order to compensate for that difference. So just be mindful of that. It's a great question to ask to save yourself again some money as well as some frustration of being in a home that you now no longer can afford or you just kind of don't want to make that payment. Um, so
That
be
happened to
mindful of
my
that.
daughter. I was telling you that happened to my daughter. She bought a
Mm-hmm.
brand new home. She could afford it at the time. And she was the first one in this community. So it was, vacant land. And then they built all around it. A couple of years later, the taxes went up. It's unaffordable now. So,
Yeah, and
Mm-hmm.
I think it's important to remember that's not just D.R. Horton, like you said, right? It's any new construction that you do.
yeah.
The initial taxes are going to be based on the land only. And so that's any builder that you work with, double check that.
So is there a lawsuit? Because somebody mentioned yesterday at an event I went to about the D.R. Horton lawsuit. Is that what the lawsuit's based on?
So
Yep.
what happened is, as a homeowner, it started with homeowners realizing like, okay, where is this difference coming from? And so a guy had his monthly mortgage payment was a little over $2,100. And then after the first year, the mortgage company came back with the escrow analysis, and it was determined that his monthly payment was actually going to be 3,100. Now, the issue and the reason that they're being sued is because they were the filing sites that they were lured into, consumers were lured into purchasing these homes under the umbrella of you're going to have a low monthly payment. That was the whole advertisement, but that determined that that wasn't actual fact for the full term of their loan because they were not fully disclosing the full property taxes upfront.
Okay.
And so that's how it came about. And so, yeah, it's going to be interesting. I feel like more people are going, more companies, lenders, builders, lenders, as well as lenders in general, are going to be called to the carpet for this because it is a common practice in order to get people in. And it just takes a few extra steps to estimate those taxes based off land and improvement. So when you're at rule of thumb, you can do it yourself. So whatever the tax rate is for this new community, multiply that percentage by your purchase price for the home. And that will give you a better estimate than just what they tell you on the on your loan estimate or the monthly payment that they're giving you. So multiply the tax rate by the purchase price. And that's where you're going to get your actual taxes for the year. And then you take that amount and divide it by 12. And that will give you the dollar amount that will be added to your monthly mortgage payment to cover the property taxes for that.
Yep.
Good info.
Awesome, awesome. So very good. That concludes our hot topics for today. And now we're going to get into our juicy content. I'm very, very excited to talk about this topic because it is so necessary, which is probate and estate planning. And so we have, again, the wonderful attorney, realtor, investor, Shema Freeman with us. And she is going to just talk about a little bit about what she does, and then we'll open it up for questions. But Shema, go ahead and tell us about yourself, and then tell us about what we need to know about probate and estate planning.
Fantastic. Yeah. So a little bit about myself. Again, my name is Dr. Shema Freeman, Esquire. I'm a Florida girl through and through, though I now reside in Texas, the great state of Texas, I have to say. Um, I did all of my undergrad and grad school work at the University of Florida, as you can see. Huge Florida Gator. I fly my flag proudly. Did my law school work at George Washington University in DC. And I actually started off in patent law back in was at the patent office at 2008. So I've been uh, in the law world for a little while. Started off in real estate in 2010 as an investor. Um, and at some point, I got tired of working at a law firm. And so then I decided to make my side gig, my full-time gig. Ended up getting licensed. So now I'm a licensed realtor in both Florida and Texas, as well as a barred attorney in both Florida and Texas. When my mom passed a few years ago, that sparked my interest in probate and estate planning, just dealing with her estate. And so I decided to open a firm and change my focus, and that's what I do now, primarily for a living.
Awesome, awesome. Thank you so much for that. And so, talk to us about what are your, like, you shared your personal experience, right?
Sure.
This was born out of a personal experience. So, what are your like major hot buttons, right, that you try to convey to all of your clients in regards to probate and estate planning?
Well, let's start with first what probate is, right? So probate is the legal process of closing down someone's estate when they die. And that is everything from paying off their last set of debts, making sure their property gets transferred or sold, and then also paying their final taxes, right? Or at least filing their final taxes. So what, in my case, what kind of sparked it is I'm a smart person. You know, I got a lot of degrees, went to law school, and we had some time to prepare for my mom's death. And even in that time of being able to prepare, there are still things that we missed in getting her estate finalized. And so it was, you know, 2.5, almost 3 years later, I was still dealing with some aspects of her estate, just because we didn't have, you know, she didn't have a beneficiary on certain bank accounts, or hadn't updated an address on other accounts. And so just getting that final bit of paperwork and closing down those accounts just took a long time to deal with. And so it was like, well, if I have all this education and knowledge of estate planning and probate, and it's difficult for me, then it's got to be difficult for a lot of people that don't have that background. And so that's what got me into it. The fact is, we're all going to die at some point. And so we all need to deal with this idea, first of, you know, being, having an understanding that we are going to pass, right? And then being able to set our families up in that transition when they are now taking over our estates, and giving them a plan to deal with that. So that's where the estate planning part comes into it, right? So if we're all going to die, the state has a plan for your assets and your liabilities, regardless of whether or not you actually have an estate plan, right? So why not it be you deciding where your assets go, how you want to pay liabilities, and all those things. And so everyone is going to die, so everybody needs an estate plan. I think it becomes even more important when you have minor children involved, because you want to make sure that those kids are set up both financially and then also with the people that you want them to be with. And the only way to guarantee that they go to the people, and I say guarantee, it's like a 90% guarantee, right? Because if you pass and that person is still not in a position to be able to take your kids, the state will still decide, you know, what's in the best interest of those children. But one way that you can almost guarantee that your kids are taken care of by the people that you want to be taken care of is through a will. So there's
So
that.
I hear even if you have a will, you can still have to go to probate if you own property.
Absolutely. So a will is just a list of instructions, really. So regardless of whether or not you have a will or not, you still have to go through probate, because probate is the only legal way to actually close down an estate. So if you have a will, it makes the probate process a lot easier because, again, you have that instruction manual. If you don't have a will, it can be a rather long process, because the courts are involved at every step at that point. But if you have a will, then you will appoint someone in your will to be responsible for taking care of your estate, and the court generally signs off on that. If that person, you know, is a good person and doesn't have any felonies or anything like that, then the court would generally sign off on that person being able to handle the estate. So regardless of whether or not you have a will or not, you still have to go through a probate process. It's just a matter of how complex the probate is at that point.
Okay.
And then, well, I'll go ahead and throw this out there because I know it's a hot topic in on the internet and on TikTok is trust, right? So a lot of people are talking about trust now, and that is a way to avoid probate if the trust is set up properly and if everything is retitled. So there is a mechanism to, you know, have to not have to go through probate. But again, you definitely need to speak to a licensed attorney in order to help you set up that trust and get everything funded properly so you can avoid the probate process.
You mean I can't go to ChatGPT and ask it to write a trust for me?
You could. I'm sure it'll give you, you know, an interesting document. But I would still rather you speak to an attorney to make sure, like the actual drafting of the document. That's, I won't say it's easy, but that is something that ChatGPT can do, right? But the issue comes in actually transferring the properties, right? So you need to actually draft a deed, get it notarized, get it filed with the county, So those are all the things that an attorney will help you with on the back end. Um, is the actual what we call funding. So getting the bank accounts changed over to the trust if that's necessary, making sure your beneficiaries are um, are right in the document. So yeah, you could actually absolutely go to chat and have chat draft a trust for you, but someone who practices this field will be able to advise you on what they actually need to be in the trust, because there's well over 50 different kinds of trusts that you can put together. So um, yeah,
Wow. No,
there's a lot to it. And in
so
particular, if you're trying to, if you're trying to prepare for someone that has special needs, if you have a minor, like those are all different types of trust that you need to put in place that will serve that person long term. So yeah, chat will do it, but I guarantee you an attorney will do it better.
There
so
you
can I ask
go. There you
about
go. It's a professional.
a land trust?
A land trust,
Uh-huh.
yes, a lot of investors use those. So that kind of gives you two things. It gives you a level of anonymity, right? So people don't know who actually owns the property. Um, And so, yeah, there's layers to this, right? So your land trust can be owned by an LLC, and the LLC is then owned by your family trust, and there, like I said, there's levels. So this is why I say yes, all these things exist, but definitely speak to a professional about what your actual goal is, because a lot of times, a lot of those things are overkill, right? So you can do if you're just looking, a lot of the times what I see is we're dealing with property. And so in Texas, there are a few different ways to transfer a property without ever having to go through probate, right? So if there was a will, you can do something as simple as amending a title. If there's not a will, you can still do an affidavit of heirship. You can do a determination of heirship. You know, you can do a ladybird deed if that so there's lots of different ways to, if we're just talking about real estate or real property, that you can transfer that. And a lot of times, even when it comes to personal property, we have the small estate affidavit that you can do, right, that doesn't involve probate, but all those things still require you to speak with a professional that knows what they're doing.
Mhm.
Yeah, I'm gonna
Absolutely,
try to do it on
absolutely.
your own.
That's very good information to make sure that you have and make sure that you cover um, yourself. And I think that, yeah, TikTok, Church of the TikTok is very much on the trust bandwagon of, oh, yeah, 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 do the trust, do the trust. And I think that people are rushing to put assets into a trust without fully understanding what they're doing, as well as maybe not even really having enough going on to need the trust, right?
Right.
So now you've put all this money into formulating this trust, but you've only got a house, maybe a couple of rental properties. Like, at what point do you feel like it's necessary? Is it a dollar amount? Is it an accumulation? At what point is it really necessary that you may start looking at a trust?
That is a really good question. I would, it's a very individualized question, because everyone's estate is different, like you said, right? And I think I'll need to go back a little bit too and talk about a non-probate asset versus a probate asset. So a lot of things that people normally have are not really probate assets. So if you have an insurance policy, that is not a probate asset. If you have a retirement plan, that is not a probate asset. So when you name the beneficiary of those things, that is going to go outright to that beneficiary. So you don't need to worry about a court for that. And even when you have property, there are ways, like we just talked about, to deal with transfer of that property without having it be a probate estate asset, especially if it's your homestead. So I think it really depends on what your goal is. If your goal is to be able to set up the next generation of having a long-term way of giving them payments, or giving them or passing on an asset that you want to go for multiple generations, then yeah, you want to think about a trust in that situation. But that is a long-term that's a long-term plan for dispersing your assets. I think most people, and I'll also say it's state dependent. In Texas, probate is actually can be a very quick process. So if you have a will and that will is properly notarized and witnessed, and very easily laid out, then probate's only going to take you a couple of weeks, right? So I think that's what people are worried about. If the will is not contested, then you can speak to an attorney, they can file the paperwork, and then within about 3 weeks, you're having a hearing. That hearing is only 5 minutes, right? The judge is going to say, yes, I agree that this person is legally competent to be able to handle the estate. They'll sign off on it that day. Um, so yeah, I really ultimately depends on what assets you have and what your ultimate goal is. But if you don't have any probatable assets, you can probably get by on a will, and then some other documents. So we didn't talk about like what happens if you're incapacitated during your life, like you're still living, but maybe you have dementia or something like that. So there are ways that we deal with that through a power of attorney, both a financial power of attorney and a healthcare power of attorney. So those three documents together are what most people will need. If you are a business owner, if you are a real estate investor, then we might want to look at doing some of that layering with a trust, right? Because then you have to think about who's going to take over my business when I'm not here. What do I want done with those properties when I leave? And so on that level, yes, you can do that in a will, but it's a lot easier to give those instructions and pass that on in a trust.
Gotcha. Good to know. Good to know. So, I had a situation of um, a person dying without a will. Um, their only family, so it was basically like proof, and we were trying to do the affidavit of heirship. Okay, the particular person. Um, so previously, basically, it was two family members living in the house, a parent and a child. The parent, when their parent passed away, the child did an affidavit of heirship in order to assume the property. Okay. Um, the witness, right? So the witness has to be a non-relative, a person that's not interested in, has no interest in the
Right.
property.
It's not a
Fine.
direct descendant beneficiary. Yeah.
Exactly. Okay. So this particular person signs this affidavit when the mother passes, right? So fast forward to when the child passes, and now the child is trying to do so the child has passed away, and now the same person who was a witness on the mother's affidavit of heirship is now trying to procure the property, right? And so in those dynamics, right, it basically boiled down to just be honest, like just keep it honest, right? Do the right things, but talk to us about that when a person dies without a will. What are the steps? What does that look like in assuming real estate?
Yeah. So you
It's
mentioned
not super
like,
straightforward, but
yeah, no, it's not, but the process is similar. Um, you mentioned the affidavit of heirship. That is, I would say, the primary tool that we use to transfer a property when someone when you're not going to probate the will, or if you don't have a will. That's probably number one. That's the number one tool we use to transfer real estate. And you did mention the disinterested witness. That is the key to it all. So it cannot be a direct descendant of the decedent. It has to be someone that has known the family for 10 plus years. So you can't just like pull somebody off the street and be like, sign this form, right? So and again, do your vetting and be honest. But it's a similar process. So you would still go to the court with those witnesses, because if you don't have a will, you would still need to prove that the person actually is dead. Usually that's done through a death certificate, right? But you still need those witnesses um, to show that these are the people in line of the family, regardless of whether or not it's an affidavit of heirship or just a probate in general. So that is the key. And I think it's harder when you have a situation like that. Like friends of the family are usually the number one people we go to for an affidavit of heirship, so we can avoid the intra-family kind of discourse that happens, right? Because you're still going to have aunts, uncles, cousins that are descendants, um, if there's no child, because of just the way the map works. So friends of the family are usually the way to go, because an aunt, an uncle, a cousin can always be tracked back as a descendant. So yeah, that's the number one. Is while we will want to use those people because we know that they know the family, it's always best to go to the decedent's friends that can speak, because they are truly outside the line of the family. It's the word I'm looking for.
Lineage.
Lineage. That's a good one. It's because it would take so long to get to a friend that, like, there's no natural flow of intestacy to a friend of the family, right? There is a natural flow. There's a protocol for how the law will dictate who gets what when, and a friend of the family does not fall into that line naturally.
Yeah. Very good. Yes, so very good advisement there, and just keeping it honest and keeping that line. But basically what I'm hearing, Shema, is we need documentation. So and you this the three things, because everybody knows about a will. Everybody now, because of media, right, is on the trust bandwagon.
Mm-hmm.
But what I heard was the key essential documents that you need to have in place are the will, a medical power of attorney, and the financial power of attorney.
Absolutely.
That's going to allow access to bank accounts. If you're incapacitated, the medical power of attorney says who does what, do not resuscitate, all that
Correct.
good jazz. And then your actual will providing the instructions for where things go and what's supposed to be done. Um, in the will, should I include my like funeral services and or cremation and all of that? Should that be included in the will?
We don't necessarily include it in the will, but it is something that we work through during the process. So you definitely want to leave instructions for your family members. Like I said, we had time to prepare for my mom's passing, and so she had everything down to who to contact for ushers, right? What verses and songs she wanted played at her funeral. So to the extent that we have it in the will, it'll be just a line or a paragraph that says I want to be cremated or I want to be buried, but the actual instructions for that funeral should be in a separate document. And all of this, you need to let someone know where these documents are at the end of the day, because we can do all this work and nobody knows that it's done, and then you're still back probating, because nobody thinks there is a will. So while the attorney or the professional that you use cannot hand those documents over to someone, you as the person that created them should be telling people where they are. Keep them somewhere safe. I recommend a fireproof, waterproof uh, lockbox, so that if the absolute worst case scenario happens, there's a good shot that those documents are still secure. And keep them with your passport and all those important documents that you need to hold on to, your deeds to your properties, any life insurance policies that you have. You want to keep all those documents together in that fireproof, waterproof case. Uh, I forget what the actual question was, but yeah, you. So I
Asked
hope I
and
answered.
answered. Asked and answered. And then those documents, so do we need to have them notarized? The medical power of attorney, financial power of attorney, and the will. Should all three of those be notarized?
Yes, to as a short answer. And in particular, the will, it needs to be notarized and has to have two witnesses to the will. The other documents, you don't necessarily need a witness, though I would recommend it. I would recommend all of them be notarized, though the medical power of attorney doesn't necessarily have to be notarized. The financial power of attorney, you need to have that notarized. You need to actually file that with your bank. You need to do that regularly, like every 2 years at least. That financial power of attorney needs to be updated. Um, with what happened with the mortgage issues back in the 2000s, banks got a lot stricter about who they give access to your accounts. So a lot of times they won't take a power of attorney that is older than 2 years. Some won't take it if it's older than a year. So those are things that you need to revisit on a regular basis. When you go into major surgeries now, most hospitals or treatment centers will actually require you to either fill out their medical power of attorney. If you don't have one, they will most likely ask you to fill that out, so they have someone to contact on your behalf. That will also include any HIPAA compliant notifications. Obviously, HIPAA is what allows people to have access to your medical records. And so you would do those together in tandem. You would need both a medical power of attorney and a HIPAA release form. So that allows the person that's speaking for you to have access to your medical records. And then it also allows them to act on your behalf.
Good
Okay, so
information.
medical power of attorney and what was that second
It's called
document that
a
goes with it?
HIPAA information release.
Information release. Perfect.
Spelled HIPAA.
There you go.
So hearing is if I'm going in to have a major surgery, I need to pack a go bag that includes my medical power of attorney and HIPAA because you never know what's going to happen when you get to the doctor and things like that. And just
Yep.
having this stuff, this is about preparation, guys. So making sure that you are prepared in all circumstances. And I know like the younger you are, the harder it is to like wrap your head around needing these things, but anything can happen. And so just go ahead and set it up. Like, I think this is a great thing between the ages of 18 and 21. I foresee, like, get this stuff in place. Like, it
Yeah.
sounds crazy, but like Shima said, update it. Just keep updating it.
And it's cool
Um,
that you brought up the 18 to 21, because what most parents don't know is that when their child turns 18 and graduates from high school, they no longer are automatically granted access as either the decision maker or the record holder for their child, right? So you can call up that college, and even if you're the one paying the financial aid or the financial bill, they can't actually release financial information to you without a power of attorney. Um, and so yeah, a lot of parents don't know that. So I actually do at the in that May, every summer I do a new grad will session. It's a very simple will that we do. Everything goes back to the parents, but we go ahead and do that drafting for them so that they have it ready to go when it's just another thing, another item to add on the going to college checklist.
I love that. I absolutely love that. Yeah, because nowadays, if you take your child to the doctor at 16, they ask the child if they want the parent in the room.
Correct.
I'm staying, but they ask, and you just gonna have
Yeah.
to work that out.
So at 18, parents lose all that access automatically.
So, okay. I love that. I love that. Well, listen, this has been a great conversation. Vanda, do you have any more questions?
I do. I don't know how long we're gonna stay on here, but I wanted to ask Shima about I have a girlfriend in the situation, and her family has got 200 acres, and the will says it can not be sold or subdivided. Well, it can't be sold unless everybody is in agreement, all the
There you
descendants,
go.
and it can't be subdivided. So the
Yeah.
person that was living there was paying the taxes, and he ended up dying, and now his wife is the only one there, and she is not a descendant. And so I just want to know what kind of advice I could give her for the 200 acres, because that's why a lot of people lose land is because
Yeah.
of these kind of issues.
I
And
have I have a number of those have had and have one where it's similar, not quite 200 acres, but it was land that they've owned since I believe 1908, and it's just continued to pass to generation, but nothing has ever been probated. So the family has just always been around and on the land, and now we're getting to the point where nobody is living on the land anymore. They want to do something industrial with it, maybe lease it out as farmland and things like that. And so now we're having to deal with going through all those probates. And um, when my particular client, he's on like the fourth or fifth generation of this land. So his actual like fractional ownership is like one like 150th%. Like, it's like something very, very small.
Uh-huh.
But then you think about like you have to get all of those people to agree on something. It's hard enough to get two people to agree on land. Imagine having to get or to agree on dinner, right? Imagine having to get 64 people to agree not only to sell, but sell at a specific price to a specific person. So all those generational properties, start dealing with those now. Like having those conversations to get everybody on the same page now. Put it in a trust, in a family trust. You name every single one of those people the beneficiary. Have the most responsible person in charge as the trustee, and allow that person to make the decisions. But in your specific case, Vanda, the wife will have a lifetime residency on the property. But since she is not in the family line, she cannot. And I'm assuming, oh, the pup wanted to say hi again. I'm assuming that the husband didn't have any kind of will that would, have his share go over to her. Texas is a community property state, so she does have some ownership in that way. But really, that's going to be a very expensive and highly contested situation, depending on how many people are involved. Because everybody there's a chance that everyone could hire their own attorney in that situation and all kind of duke it out, for lack of a better a better way of putting it. So yeah, you could that unfortunately your friend could be dealing with attorneys for a long, long time in that situation.
Wow. Yeah.
So unprobated, to go that many generations unprobated is basically saying that the original person who bought it in 1908, their name is still listed on that
Correct.
property, correct?
Or if it's not
In
their
the
name,
estate
because
of.
there is, yeah, in the estate of, because there is a record of their death somewhere, and tax records will, once they realize that that person is dead, they will automatically send over to the estate of that person. But if it's still in the name of the estate, that means it hasn't been probated. And so each level will need to, and if people have died on the next levels, then their estates need to be dealt with
Yeah.
and all of that. So yeah, I have that one case. Um,
That's
I basically told them they need to work this out amongst themselves, because if they want me to do it, it's going to be expensive.
yeah.
But
Um,
there's a form that they can complete, right? That allows them to say, I have no interest in this
correct.
property.
Yeah,
And they
they
basically would
can waive
sign
their
away their
interest, and
rights.
that's the easiest way to deal with it. Like for the people that want to be involved, they can be involved. For those that don't care about their 1/300th fraction of the property, they can waive that interest. And we do see that a lot. But yeah, this one particular, it took me probably 2 weeks just to figure out who all the descendants were, and that's not even contacting them. That's just like talking to a few people to try and get the actual family tree designed, going through ancestry. So a lot of people don't know that too. Like the courts will hire what we call an attorney ad litem. So I think most people have heard of a guardian ad litem. That's for minors or older people that can't act for themselves or want to make sure that we can act for themselves. But we also have what we call attorney ad litems, and they do the investigative work. So I've done that for cases too, where we go into ancestry and we will find the people, and we will contact as many people that we think could be possibly related, to bring them into the case, just to make sure we get everybody. So that there's a lot that goes on behind the scenes in cases like that too.
Yeah.
That's interesting because my client actually had to do that for themselves. They had to do the investigating. They had to submit all the forms in a packet, proving that they were the heir to the property.
Yeah.
So they all know the heirs, but they're all not in agreement with what to do. Some want
Yeah,
to sell and some don't want to sell, and
that's the contested part. Like they can choose to buy each other out. They can choose to waive their interest. Um, Ultimately, a court may decide that like we have to subdivide this. We have to partition it, is what we call in the real estate world. And so that may be a provision in the will that can't be abided by. But that is for ultimately a court to make that decision.
okay. All right, I will definitely share this information and this recording with her.
Absolutely.
Thank you, thank you.
Absolutely. Absolutely. Well, thank you so much, Shema. We really appreciate you sharing this wealth of knowledge with us so that we can be better prepared for not just our passing, but for our living at this
Yes.
point. So, really appreciate you taking the time. How can the people reach out to you?
Sure. My website is www.urithilaw. That's RUITHI law.com. You can also reach me at sfreeman@urithilaw.com. Or you can call the law firm. It's 352-519-0001. Or follow at
Okay.
Urithi Law on Instagram. I just got that
All
up
right.
a few days ago. So, in anticipation of this. So, here we go.
Spell that again.
URITHI, Urithi. It
And what
actually
that?
means heritage or inheritance in Swahili.
Oh, okay. I was going to ask you what that meant. Okay.
My name means beautiful in Swahili. I love it.
Yes, ma'am.
In Swahili. Okay. All right. So definitely give Shima a follow as well as reach out to her for all of your estate planning needs, probate questions, discussions, and things like that. Reach out because she's definitely a wealth of knowledge and can assist you in getting things sorted out. As she stated, she is licensed in the state of Texas and in Florida. So if you happen to be in Florida and listening, reach out. Thank you so much for joining us today. You can reach me at RE with Janila B on Instagram, Janila.Brown on Facebook and social media and YouTube, as well as you can call me at 281-215-3307. And then Vanda, how can they reach you?
On Instagram, I am the THEEXP mentor, and on other social platforms, just Vanda Crossley. And I can be reached at 281-717-6330.
Awesome. Awesome. Well, thank you so much for joining us today. Again, you can find this recording on YouTube, Spotify, Apple Music. We will get that out within 48 hours. You all have a blessed and wonderful day. Take care.
Thank you. Bye,
Thank you,
everybody.
guys.
Thanks, Shima.